The ratification of the 14th Amendment to the United States Constitution has been dubbed by many to be a new founding for America, and I would be inclined to agree. The 14th Amendment signaled the end for the republic that was supposed to be, a death knell of sorts, and laid the groundwork for the horror that was to come. The 14th Amendment has been used as weak justification to violate the sanctity and exclusivity of American citizenship, something which is key to maintaining national sovereignty, identity, morality, and culture. To properly understand how and why this came to be, we must analyze the political situation in the United States at the time in which it was ratified. The year is 1866, and the bloodiest conflict in American history to date, the American Civil War, has just come to a close. 620,000 American men and boys fell before their time, and the continent was ravaged by war in a way that has not been seen before or since. This was a close-fought thing. Had one or two minor elements of the war been different, the American Confederacy very well may have succeeded in their revolution. Though the Confederacy had been thoroughly whipped by war's end, the specter of Southern rebellion still lingered in the minds of the victors of the war. And so, two key things were on the minds of the victorious Republicans in Congress. Firstly, they wanted to appease the more radical elements of their own party, and secondly, they wanted to salt the earth of the Southern political landscape so that the menace of armed rebellion could never again be cultivated. To that end, the victorious Union took steps to neutralize Southern political power and entrench Republican control over the South. In 1866, the United States Congress passed the Civil Rights Act, which sought to define American citizenship, the rights which come with it, and declare it unlawful to deprive an individual rights on the basis of color or servitude status. That is to say, the Republican Congress wanted it codified into law that it would be illegal to deny the vote to newly freed slaves who would be sure Republican voters. This would prove to be the thin end of the wedge. In the words of self-described radical Republican Congressman James F. Wilson, the Civil Rights Act of 1866 provides for the equality of citizens of the United States and the enjoyment of civil rights and immunities. What do these terms mean? Do they mean that in all things civil, social, political, all citizens without distinction of race or color shall be equal? By no means can they be so construed. Do they mean that all citizens shall vote in the several states? No, for suffrage is a political right which has been left under the control of the several states, subject to the action of Congress only when it becomes necessary to enforce the guarantee of a republican form of government. Nor do they mean that all citizens shall sit on the juries or that their children shall attend the same schools. Though this quote is about the Civil Rights Act of 1866, bear this in mind as we go forward. The Civil Rights Act of 1866 and the 14th Amendment were very similar documents supported and written by much the same people. To further divest white Southerners of their political power, in order to regain their vote, Southerners would have to swear what was called an Ironclad Oath. I'll read the text of that oath verbatim. I do solemnly swear that I have never voluntarily borne arms against the United States, since I have been a citizen thereof, that I have voluntarily given no aid, countenance, counsel, or encouragement to persons engaged in armed hostility thereto, that I have neither sought, nor accepted, nor attempted to exercise the functions of any office whatsoever, under any authority or pretended authority on hostility to the United States, that I have not yielded a voluntary support to any pretended government, authority, power, or constitution within the United States, hostile or inimical thereto. And I do further swear that, to the best of my knowledge and ability, I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely, without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office of which I am about to enter, so help me God. Consider for a moment how exclusionary that oath is. That would exclude the drummer boy in a Confederate infantry regiment. That would exclude a farmer who sold grain to the Confederate army. That would exclude anyone who did business with the Confederate government. Demographics are destiny. And these exclusions, in tandem with the high freed black population in the southern states, allowed Republican coalitions to carry the elections in every southern state except Virginia in 1870. Now, full disclosure, in 1871 Congress did revise to allow for the swearing of future loyalty, and it was fully repealed in 1884. Now, Republican legislators were afraid that the 1866 Civil Rights Act would not stand on its own when challenged in court. To that end, they drafted the 14th Amendment to the United States Constitution, the original intent of which was to prevent states from disenfranchising and denying citizenship rights to newly freed blacks. Now, this fact in and of itself is not why I say the 14th Amendment is the death knell of the American Republic that was. The real problem lies with the birthright citizenship clause of the 14th Amendment, which reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." This clause has been interpreted by modern courts to mean that anyone born here within the borders of the United States is an American citizen, regardless of the citizenship status of their parents. Now, this interpretation, along with other acts of legislation down the road, such as the Hart-Celler Act of 1965, have allowed for the massive demographic shift which has completely eroded away the American Republic that was. Now, foremost among the things the Supreme Court is supposed to consider when interpreting law is the original intent of that law. So let's take a look at what the authors and supporters of the 14th Amendment had to say at the time. The author of the 14th Amendment, Jacob M. Howard, was questioned as to whether or not this amendment would grant citizenship to Native Americans within U.S. territory. His original intent was that it excludes Native Americans who maintain their tribal ties, and persons born in the United States who are foreigners, aliens who belong to the families of ambassadors or foreign ministers. I say again, the author of the 14th Amendment says that it was intended to exclude foreigners and aliens. It's clear that this was the prevailing opinion at the time as well. In the Senate debates on the ratification of the 14th Amendment, Senator Lyman Trumbull says, "What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means." Similarly, Reverdy Johnson, a U.S. Senator at the time, agrees that it means not subject to some foreign power. And there's roughly 30 years of U.S. case law to this effect before justices start legislating from the bench. In the slaughterhouse cases, a majority of the Supreme Court said that the phrase "subject to its jurisdiction" was intended to exclude, drumroll please, ministers, consuls, and citizens or subjects of foreign states born within the United States. In Elk v. Wilkins, the court ruled that just being born in the territory of the U.S. is not sufficient to grant you citizenship. You have to be born subject to the jurisdiction of the United States, i.e., not from somewhere else. It's not until U.S. v. Wong Kim Ark in 1898 that the Supreme Court deviates from this. They throw out precedent and original intent in favor of some nonsense about English common law. And this insanity culminates in 1982 in Plyer v. Doe, which holds that U.S. states are obligated to provide essential and very expensive services to illegal immigrants because they're somehow subject to the jurisdiction of those states, which is just pure nonsense and sophistry. This amendment, and admittedly its willful misinterpretation, laid the foundation for the demographic and political shift here in the United States that have transformed this nation into something that would not be recognizable by its founders. Now, this amendment contains language which heretofore has gone unmentioned. The language in question reads, "No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability." Now, in the context of the time, this was clearly aimed at preventing former Confederates from holding office, to further deprive the South from any sort of representation in Congress. In the modern context, on the surface, this seems reasonable. In so many words, it says that enemies of the state shouldn't be allowed to hold office. Here's the rub. American society is more polarized than it has been at any point since the American Civil War. There has been, in recent days, a concerted effort on the left to try and bar Donald Trump from running for re-election due to January 6th. There exists no real legal litmus test in the United States for what exactly constitutes rebellion or insurrection. It is conceivable that in the near future, certain political candidates could be precluded from running for or holding office by virtue of the fact that their political adversaries have labeled their political activities as rebellion or insurrection, regardless of whether or not that's actually the case. That's concerning, to say the least. I'm Jim Dewey, and this has been Combating the Narrative. Now, I've been told I'd probably have a much larger viewer base if I actually asked people to subscribe and hit the like button, so go ahead and commit an absolute war crime on that subscribe and like button. I want the UN to have to convene a war crimes tribunal. No, but jokes aside, if you have watched to this point, you probably enjoyed my content. Consider liking, subscribing, and sharing. I recently hit 100 subscribers, which is a pretty big deal to me, though it may seem small to you guys. I couldn't have done it without each and every one of you.